Welcome to Power Up Your Practice, the go-to podcast for law firm owners and managing attorneys working on the business, not in it. I'm Ruby Powers, your guide into the heart of law practice management, bringing you insights from leading legal minds, trailblazing attorneys, and expert guests who provide you with an actionable perspective on running your firm more effectively and efficiently. Prepare to open your mind, be inspired, and power up your practice to the next level. Hi, everyone. This is Ruby Powers, your host and companion through the ever-evolving landscape of law practice management. And thank you for joining Power Up Your Practice. Each episode, we're going to hear from our guests and learn about their perspectives on law practice management and reaching success. And we're so excited here today to have two amazing guests. We have Jayne Reardon, who is the partner and deputy counsel of Fisher Broyles, and she's also the former Executive Director of the Illinois Supreme Court Commission on Professionalism. And we also have Reid Trautz, who is the Senior Director of the Practice and Professionalism Center of the American Immigration Lawyers Association. And I've known Reid for a long time, and he's a longtime mentor and friend and guide. And Jayne and I have met through the ABA Law Practice Division committees and activities, and it's quite an honor to rope them in both here, thinking about rodeo here in Houston today, soon after the ABA Tech Show. And what I really was wanting to get to have both of them together was to ask them a lot about their panel that they had at the ABA Tech Show not too long ago, here in February in 2024, and we're recording soon after, about the future starts here, technology and the next era of legal practice. So Jayne, Reid, why don't you let us know a little bit about yourselves, and then we'll dive right into that discussion. Go ahead, Jayne.
Okay, well, I don't want to belabor the point, but I've been an advocate for the use of technology in the legal profession for a number of years, decades, frankly. And I was thrilled to be on a panel with Reid and Dan Pinnington and a couple of other panels at this ABA Tech Show. I feel like we are on the cusp of some real change generated and motivated in large part by technology and generative AI. So we're at a real exciting point in the legal profession. And so I'm happy to be here talking with you.
I agree with that, Jayne. We did the opening plenary panel for this tech show, and it was exciting. And I got to say that my first technology CLE as a lawyer was in 1989, not to date myself, but I chaired the planning committee for Tech Show in 2012, and this was my 21st Tech Show that I've attended or been a faculty member of. And I have to say, I was left there maybe more excited than I have in a long, long time because of the changes that are now embracing the profession. And, we had a chance to talk about it then. And I'm glad we have a chance to share it with an audience here today, because these changes are going to change our profession over the next decade.
So for those who might not have gone to ABA Tech Show, what are some of the key takeaways that you would say from this discussion that people need to know? And I'll also mention what I've seen just from one year to the next at ABA Tech Show, just a dramatic shift in the conversation. So I felt like I left with more, I know you said excitement, but I felt like I left with more questions and sort of pondering the existential future of the practice of law than ever before.
And if I could just start by saying, right, we're talking about generative AI, everything that flows from the launch of ChatGPT and the other products that are out there. But last year at Tech Show, it was kind of a novelty, right? People were like, oh, this is fun. This is going to be different. And this year, people were a little more serious about, hey, this is going to have an impact on the profession. How can we embrace this? It was a big change, but we're still very early in that change.
Yeah, I would agree. I think that generative AI is overshadowing all of the tech show or technology products out there. There are still a lot of advancements being made in non-AI or generative AI space, but this is the sexy new thing. And from my perspective, I'm not a techie by any stretch of the imagination, but from my observation, what we have going here is we're not going to just speed up existing processes that have been in play for decades in the legal profession. Let's just do the same thing, only faster is out. Generative AI is going to transform, is already transforming the way we work and who works in the legal profession. It's really quite fascinating.
I heard a great podcast with Richard Susskind about like one of his latest books about the future of professions, and just exactly what you said, Jayne. But I think a lot of lawyers, when they look at a tool or technology, they think, "Oh, I'm just going to be faster and quicker and a little more efficient." But what Richard Susskind says is like, we need to reimagine what the practice, the professions will be, like it'll specifically be the practice of law. And what could that be? Because now the tools, it's almost like the rules, it's like the game has changed in a way. And that the tools that we have, the parameters that we have are really going to be changing dramatically. We've already seen that in the last year, but like I think the sky's the limit in the coming days.
And I think that one of the biggest changes that will happen is this is the first real challenge to the billable hour, right? Because many of these processes can now help a lawyer, right? It's not just about robotics and speeding things up. It's about helping us think through things faster in more detail, so that so these generative tools can help us draft pleadings, come up with ideas for challenging the concepts in a brief that our opposing counsel has filed, so much more depth and faster, but at a reduced time, right? We won't be able to bill the hours that we once billed. I mean, I'm hearing people say what might have taken associates and others maybe 100 hours can be done in less than 10, right? Maybe even less than just a few hours. So that how do we get the value as lawyers for what we're putting into a matter when it can be done much more quickly? Now, not everything is going to change, right? We still counsel lawyers or counsel clients. We still, have meetings, we communicate. There's things that generative AI isn't going to do for us, right? So those things may still be billed on an hourly basis, but I think we're seeing this change. And if some of these bigger firms that are built and leveraged on having, hundreds of associates do work, we may see a change in that structure of big law firms going forward. Again, may take a decade, but these are clearly on the horizon.
I don't think it will take a decade myself. I am also on the AAA neutral roster, and an example from the arbitration world was typically when an arbitrator prepared a scheduling order after the first preliminary hearing with the parties. It might take an hour or an hour and a half to get it all done and uploaded. Now there's a generative AI tool where it's done in 45 seconds. The hearing is recorded and a scheduling order is produced in that short of a time period. So those are efficiencies, but it also changes, as Reid said, how we value our contributions, right? For a very, very long time, we've measured that in the billable hour. And now that's got a lot of lawyers running a little scared, right? And the reality is the repetitive work that might have taken, just like that scheduling order for a neutral, can be done much more efficiently. And what happens is it frees up the neutrals or the lawyer's time to do higher value, critical thinking, connections. We don't have to be spending, a high billable rate to produce a scheduling order. That's not a good and highest and best use of our time as lawyers. So I think it's going to be a very interesting ride on that. And in terms of the ethics of it, we need to, under Rule 1.5 of the Model Rules of Professional Conduct, charge reasonable fees. It will not be reasonable. It is not reasonable now to charge an hour and a half to produce a document that can be done using a generative AI tool in a matter of seconds. So that's going to be transformative, I think. Reid and I agree on that. The billable hour is going to die, at least in some segments of the profession.
And so there's some segments, and Ruby and I are familiar with immigration, that already are doing a lot of flat fee work. This is going to be very helpful in those segments that are already doing flat fee work. So we're going to see, I think, other parts of the profession move into that as well. I also think, and Jayne and I talk about this access to justice, right? And that is that these tools aren't all going to be directed at lawyers, right? They're not just for lawyers to use. They may be for consumers to use. Consumers who are not now getting legal service, either they can't afford to make the decision, they don't need to have legal guidance, are going to turn to some of these tools to get their answer. And they may not know if it's a correct answer, right? But they may then turn to a lawyer and say, can you tell me if this is a correct answer? So the business model for some lawyers is also going to change to incorporate some of these tools, these AI tools that will be consumer facing, but then potentially confirmed by lawyers for a fee that they're correct or not correct. Or some firms will create that. They'll come and say to people, come and look up your own information with our generative AI tool and then pay us an extra fee on top of that to confirm it. So there's going to be changes at all levels of the profession. And I think it's exciting because, again, the access to justice, there's a lot of people, right, who aren't getting help. And that's an opportunity for lawyers. If we can help more people, because it doesn't take us as long to do the work, right, but we can still get paid and profitably for that quicker work, then everybody wins.
I think the two big themes were, the death of the billable hour and a little intrigue in the subscription model more than before. There used to only be like one or two people mentioning it, I think, and that it seemed like there was panels on that and more of a conversation. And then just, we always bring up access to justice. How do we better fill in that gap? And I'm really thinking about that. I think there could be a model where a firm could potentially serve the three different tiers. Maybe I'm brainstorming, trying to find a solution. One where you have like the pro se-ish people who like to do a lot on their own, but they want a little guidance or help. Like maybe it's you provide a course or some light review, or I don't know, something, that's all legal and ethical. And then second could be like more what you normally do, what you normally include in your services. And maybe third could be like your white glove service where you do more. Now, I used to say when I wrote my first book about law practice management, you had to choose what firm you were going to be, 1, 2, or 3 in a way. But now I'm starting to think, why couldn't you be 3 and 1? I don't know. I mean, that's maybe a good discussion for another day. But I do believe that having practiced 15 years, I don't see the simple stuff anymore. I see people try to do the simple stuff on their own or somehow online with a little bit of guidance. I mean, I'm an immigration attorney, and they come to me with more complex matters either after they've messed things up or someone messed it up or they just don't know how to figure it out on their own and TikTok won't answer their questions, So, but yes. So I think the death of the billable hour, the intrigue in more in flat and subscription, but also like how do we practically as a firm provide more access to justice and because there's not going to be like more lawyers, there's the aging of the bar. And I don't think that's necessarily going to mean like we need a certain amount of lawyers to provide more service. I think we've got to find a way to leverage the technology to be able to provide that access to justice and to be there.
Yeah, I agree with you, Ruby. And I think that there are firms out there who are providing different levels of service. Hello Divorce comes to mind. If you just want information, it costs X. If you want information plus a consultation, it's Y. And if you want full service, someone to do it all, it's going to be Z. There are many, many levels in the subscription model world. And I think that's what our consumers want. And you're absolutely right. There are not enough lawyers, and they're not geographically located in the places where they're needed to provide one-to-one consultation, which is the way our profession was conceived back in the 1800s and early 1900s. The world has shifted, right? So we have the technology, we have the means to provide one-to-many services. We also have the regulations. They just need to shift to be able to make sure that, as you point out, Ruby, sometimes people get wrong advice and we have to try to protect the consumer, but we shouldn't protect the consumer at the cost of providing services to large swaths of Americans, which is what's going on right now.
Yeah. And I would just say our ethical rules are really business rules. They get us to all deliver the same kind of service. And it's been hard for these companies like Hello Divorce and others, right, to break away from the model that our rules tell us we have to do. And my concern is that we have only a few of these outliers, right? And when everybody talks about subscription service, they talk about the same three firms. Why aren't there 300 firms doing that? Aren't there 1,000 firms doing that? Because the rules are preventing that. And I also think that, and if I get on my soapbox here a little bit, that mandatory bars and bar associations are not doing enough. And I brought this up at Tech Show too, are not doing enough to help lawyers, especially solo and small firm lawyers, understand and adopt technology. There are things that the bar can be doing to help filter ideas, right? There's so many choices in the marketplace. What are the choices for my area of practice, right? Help me advocate for better products on the market. Help collaborate more. Don't make it difficult to get education about technology because, those don't qualify for continuing legal education credits, right? I think bars need to get in the game to help the solo and small firm market, which will in turn unleash more access to justice, but we're just not there.
I agree. And I think that there also with the non-lawyer ownership of law firms and sandboxes in Arizona, Utah, like I feel like there's a lot of shift and movement going on. I mean, I'm in a federal practice, so that seems to attract a lot of those businesses going into that space. I think that I think as lawyers, we've been so ingrained with the way we're supposed to do things that whenever we do something of small variation, like we get a little scared. But like I did a speech about this recently about like I like board games because you have the rules and then you figure out what your goal is and you try to get from A to B as fast as possible so you can win. But I feel like the rules are shifting for us and we don't really know. And when the rules change, then it's like really not so fun to play a game because you're like, well, what are the rules, And I feel like the rules and the tools are changing. And a lot of us, the lawyers, are just like in the day to day, just got to take care of the people we have to take care of. And we don't have this chance to go to this like 30,000-foot level, which, is afforded to people who've gotten a lot of their firms running on their own a little bit and can run away to the ABA Tech Show and have these great discussions. But that I don't know. I feel like we have a lot of our hands tied behind our back, but if we don't wake up and see what's happening, then we're going to be left behind. And it's sort of like we have a lot of things stacked against us, but we've got to be a little more entrepreneurial in our mindset and find a way to help be there for our clients and what they want and how to better serve them.
Yeah, I would agree with that, Ruby. And in terms of the rules and the tools, yes, there are some changes. The rules, not so much. Yes, there's been some changes. 3 jurisdictions, the District of Columbia, Arizona, and Utah, have eased up some of the regulatory rules that kind of, as Reid said, are more business as opposed to ethical rules. For example, the rule that says you can't share legal fees with someone who is not a lawyer. And that is not necessarily an ethical rule. There are plenty of ethical rules that address lawyers need to be independent, lawyers need to use their independent judgment, etc. I think that rule was designed to keep lawyers separate from other professions. There was a kind of a hubris, frankly, written into it. If you look at the history of some of our rules, that we wanted to keep out other people. Those rules actually are hamstringing lawyers' ability to engage with experts in other areas like technology, like practice management. And they were formed at a time when all a lawyer needed to do was go to law school, learn the substantive law, deliver that law in a one-to-one consultation with their neighbor who came to their office, in a horse and buggy or a car. That is just not the way people seek to access legal services anymore. Those rules need to be looked at critically. Another one on the tools piece is technology. When ChatGPT 4 passed the bar exam in the 90th percentile, and better than 90% of the human bar takers, in 6 minutes flat, we have to kind of question, what is the unauthorized practice of law? And can we ease some of the rules around UPL, which is in virtually every state? It's designed to protect against the charlatan or the unqualified lawyer. But in these cases, when it's applied to technology and tools, it actually it may be impeding regular people having access to legal information and legal advice that can be delivered ethically through technology. We have to figure out how to ease up on those regulations so that we aren't chilling the innovation that would be necessary, that is necessary, to provide these legal services to more people and do it ethically. I think it's very doable. Lawyers are problem solvers, but we have to just hunkering down on the rules that have been the rules for decades and actually look, what are they accomplishing today? Are they really conceived in the public interest as our rules of professional conduct should be? Or are they outmoded and protecting the status quo at the to the detriment of frankly lawyers as well as members of the public?
And that makes it hard for lawyers to innovate, lawyers who want to do it differently. It doesn't make it impossible, but they do have to jump through a lot of hoops and probably face a few complaints from other lawyers saying, hey, you can't do it that way. But yes, that's why the rules need to change so that more lawyers can say, I know I can deliver it this way. I know I can do it competently and effectively and affordably. Let me do it. And that's why we need to adjust those rules. So if people out there are thinking, hey, I got a new idea, it's possible to do it. Look at Hello Divorce. Look at there's others that I just don't come to mind, but we've got to do better because the technology's there. And I that's, at the root, really what's changing, what's pushing us is as technology changes, consumers go, oh, I can do this differently now. And whether that's delivering it on their phone or delivering it via video meeting, or technology is changing the way consumers want information. So we've got to adjust to that within the profession, or we're going to be left behind.
And frankly, Reid, I think we will be left irrelevant.
Yeah.
That your average consumer doesn't think, oh, I have a legal problem, let me find a lawyer. They think, I have a problem, let me go to Google or my search engine and figure out what it is. Or maybe I ask a friend or a relative. But lawyers have to quit insisting that they are the only source of relief, because the consumers are telling us otherwise.
And I'll just share, there's a website out there called there's an AI for that.com. Okay. Just as it sounds, there's an AI for that.com. And if you search under legal advice, there's 77 different companies or entities or products that are saying we can provide some level of legal advice, either to help lawyers do it or directly to consumers. Right. So it's already started. They're already there. And we're going to see that develop and evolve into more, some are going to rise to the top, and they're going to become kind of household names, right? Like LegalZoom, but they're going to be slightly different. And we don't want to be irrelevant. We want to be part of that. As you say, Jayne, we're problem solvers. Let's solve this problem that we've created for ourselves and move forward. Anyway.
No,
And I think there's some, oh, go ahead, Ruby.
Well, I was just going to say that was another takeaway from Richard Susskind about how professions had a monopoly on information, and that's how things were passed on from one to the next, and that we were sort of in silos of information, doctors, lawyers, things like that for other professions. But that doesn't exist anymore. A lot of this information is free flowing and not in silos and more accessible, and sort of to echo what you're both saying about how you're right. I don't think they think, oh, first let's go talk to a lawyer. I think it's first let's Google or chat GPT that or something. And then if I can't find a good answer that I feel confident about, that I'll stake my life on, then maybe I'll go get a lawyer to verify or something. But what were you going to say, Jayne?
Well, I was just going to say that there are some bright spots here too. And that is many states, I think about 7 or 8 now, have allowed paralegals or paraprofessionals to deliver certain legal services. You don't have to have a JD. Supreme Courts have eased the unauthorized practice of law for some community justice workers, recognizing that, and particularly now when we have so many people speaking so many languages, part of it is just a language barrier. We have a fairly arcane legal language, but then when you have people from I think here in Illinois, there's like 88 different languages spoken in just, one of the border cities. It is helpful to have people who can take a simple document and help someone else decipher it, right? And it might be that they just understand that particular arcane language or whatever. So there's been a couple of legal challenges. One is the Upsolve case in New York, where there was a challenge to allow an exception or challenging the UPL law in New York so that a reverend and some trained up volunteers could help certain people in their debt collection situation, like something like 99% of the defendants default. And there, an organization just wanted to train up some volunteers to help the people figure out what boxes to check on the state form. That was challenged, and so far, the challengers have won. They won a preliminary injunction against applying UPL, allowing regular people to interpret this. That is a little chink in the UPL armor. And there's similarly a challenge that's coming out of South Carolina, the NAACP case, in a housing situation where there's evictions. And, we're just talking about pretty basic understanding of legal rights that's not getting to regular people. And the courts are upholding the rights to train people to provide basic legal services who are not lawyers. And it's a shame, actually, that lawyers aren't leading these efforts to make the law more accessible. That is our main job as lawyers. It is not to make money, but it is to make the law and rights accessible to the people who live here. So I think it's going to happen. And I'm hoping that lawyers help in this effort. And technology is making it so that we're not going to have much of a choice much longer.
I think when I talk to lawyers about the paraprofessional, the non-lawyer, and more in that space, usually the initial reaction is they don't want that because they look at it as a competition. And I think just in general, a theme of everything we're saying is just there's a lot of change. And I think the point of it is that society is not really going to be comfortable with the amount of change that with AI is moving. And, even the bar moves really slow. We saw it move pretty fast during the pandemic, but still it takes a lot to make it change. And
And that's what's supporting kind of my earlier thesis is if bar associations would move faster, if they would help their members move, we wouldn't need these other groups to come in and provide services. We could do it efficiently, affordably at whatever level, right? Going back to your 3-tier kind of law firm, Ruby, is that we could do that. Not every firm would do it, but we could help more people. But we just won't move, as Jayne says, because our rules haven't really changed. But now it's being forced upon us. And we've got to be ready for that change, right? Consumers are pushing the change. Regulatory changes happening, technology change, all those forces have to get us to look forward and say, how do I have to do it differently now? And I find that exciting. Others are going to go, wait a second, I've built all this, right? We get into Clayton Christensen's innovator's dilemma issues, right? I built all this. Why should I change? And the answer is because it's eroding. You built it for a client that no longer really exists. Right? Maybe some of the big firms and other things, but for the small firm, they're helping individuals and mom and pop businesses and things like that. That base is eroding.
And Ruby, to your point that what I was going to say is to your point that lawyers don't want the competition. I hear that as well. But the reality is lawyers also don't want this business. It is not lucrative business. It is individuals. It's repetitive. It's a clientele that is just not being served. It'd be different if lawyers were actually serving and providing the services for them to say no one else should do it. But to say no one else should do it and these people should go without legal help is frankly irresponsible and unethical. And it is not behooving our profession.
And I'll share one happy last thought before we close up. I actually teamed up with a nonprofit that had no legal department to help represent hundreds of Afghan asylum seekers. And if we train them, we work with them, we've gone to all their interviews, we work side by side. There were so many different languages and cultural differences, but if we wouldn't have found a way to do a low bono representation, I don't know how those people would, how they would have been served. And that was just being creative and trying to find a way to fill that gap. And but that's being innovative and finding solutions. Well, wow, Reid, Jayne, wow, I don't know. I think I made thoughts of like at least a few more podcast ideas just from some of our key conversation points. Why don't we just go to closing thoughts, each one, and how people can find you. So thank you so much for being with us today.
Well, thank you. Go ahead, Reid.
I'll just do that real quick, sorry, and say that I think firms need to set aside time to be thinking about this, right? Looking at their current processes, saying, how can we adopt this new technology, generative AI, doing some investigation, and, don't have to, remake their entire law firm, but relook at how they can do it and address the needs of consumers. That's where the profitability is going to be over the next decade. And I encourage people to start that as soon as possible.
I would agree with that, Reid, and educate ourselves. What's exciting about this is nobody is an expert on generative AI and how it is impacting the practice of law. We're all learning together. We can figure this out, and we can be part of the change that is embracing us, as Reid said in the beginning. So it's really fun, interesting, challenging, and I hope to see everyone along the journey.
Oh, wow. Thank you, Reid and Jayne. That was great. And I love the practical tip of like setting aside time, because we took a lot from this episode and just trying, how do we put some action items in place? And I think that setting some time to work on our business and finding ways to implement that and how better to serve our clients and seeing what our clients really need. So we'll put the contact information for you both in the notes, and I really appreciate both of you for joining us. I know you're both amazing thought leaders in this space, and thank you that we could find a time. Everyone, thank you so much for joining us on this insightful journey today. Your time and engagement means the world to us. And if you've enjoyed this episode and want to continue the conversation, please feel free to join us on the Power Up Your Practice Facebook group and keep powering up. We'll see you next time. Feeling overwhelmed by admin tasks? You're not alone. Many immigration lawyers are in the same boat. That's where Staffy comes in. Over 90 law firm owners just like you have turned to Staffy for help with legal, administrative, marketing, and client-facing work. Now, Staffy's mission: to help lawyers find balance while growing their firm. With bilingual virtual staff and full HR support, they take the hassle out of team management and focus on what matters most: your clients and your practice. I've personally benefited from Staffy's support with 7 virtual assistants of my own across various areas of 2 of my businesses, including my law firm. Now, schedule a free initial consultation with Staffy. That's stafi.cc, and use the code RUBY. That's RUBY for $500 off. Thank you for tuning in to the Power Up Your Practice Law Practice Management podcast. I'm your host, Ruby Powers, and it's been a pleasure sharing this time with you. Join us next week for another episode where we'll continue to explore insightful strategies for success. Power Up Your Practice with us. See you next time.